LawSikho's thorough newspaper analysis for 25th and 26th of October 2023. Now, let us start with the today's editorial section, which talks about the Telangana's law, which is under scanner, and how the preventive detention law works, which we have taken from the Indian Express. Then we'll be talking about some news update, which will include the national and the international news. And lastly, we'll be talking about some legal updates coming from the Honorable Supreme Court and the High Court of different states in India. Okay? चलो अब स्टार्ट करते हैं the editorial section के साथ. First, we'll discuss the context that why are we talking about it, and then we'll discuss how preventive detention law works under the Constitution. Now, as Telangana gears up for the assembly poll next month, its preventive detention law is in spotlight. In at least 3 separate instances, Supreme Court has given a red flag to the Telangana government about the use of that particular law. The latest was a ruling on September 4th, where a bench of Justice Suryakant and Justice Dipankar Datta underlined that the pernicious trend prevalent in the state of Telangana has not escaped the court attention. So this particular law, which is under the review by the Telangana use, is, it depends, the Supreme Court has given a warning, a red flag to the Telangana government that how this particular law has been used in the state. And this is the third instance where the Supreme Court has told and underlined the use of this particular law by the state of Telangana. So let us understand first that what is preventive detention. So what is preventive detention? Means a detention of a person. Okay, it's a detention of a person by the state without trial or conviction by the court, but merely on suspicion. So what does, in a layman language, we can say that if state finds that the particular person has done any offense which is on the basis of suspension, the person can be detained without a trial and conviction by the court. So it's a very stringent law. The detention could be up to a year unless extended. So a pre-trial detention is not as same as preventive detention. In pre-trial, the under trial accused of a crime. So while a former is an under trial accused, the person is under trial accused. While in the preventive detention law, a detainee can be taken into custody just as a preventive measure, even if he has not committed a crime. So as a measure, to take the step as a measure, the person can be taken into custody just as a preventive measure, even if he has not committed a crime. So it can be taken as a measure. In countries such as Britain, US, Canada, preventive detention is a wartime measure. They cannot exercise it regularly. But in India, the Constitution itself has the provision under Part 3 where the state has been given the power to suspend this right for preventive detention. So, despite the emphasis the court and the law gives on individual liberty, Part 3, which forms the basic structure of the Constitution that cannot be amended, preventive detention is put in that part under Article 22. So, preventive detention is given under Article number 22, part number 3, and has been given a constitutional status, constitutional validity, despite having a very stringent provisions. Now, among the central legislation, the National Security Act, the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act are examples of law under which preventive detention can be ordered. As many as 25 states also have preventive detention legislations like Telangana law, which is called the Telangana. So it has a very long name, which is mentioned in the para number 2 of this particular, right-hand side of the editorial, where 25 states have also preventive detention legislation, and Telangana is one of them. Okay. So these are very expansive laws, specifically addressed to local law and order issues. So Tamil Nadu has also the state laws, Telangana has also state laws, but these laws are very stringent. Now we'll discuss about the provisions, the legislative provisions of this particular law. Now, it is mentioned in article number 22 of the Constitution of India. So article number 22 prescribes protection against arrest and detention, but has a major exception to it. 22 subclause 3 subclause B, that none of those safeguards apply to any person who is arrested or detained under any law providing for preventive detention. The remaining clauses from article number 22 subclause 4 to 7 deal with how preventive detention operationalizes. Okay, so first, the state, which would be a district magistrate, would issue an order to detain a person which when it is necessary to maintain a public order. So one of the grounds that is given as public order can, on the basis of the public order, a person can be detained. The state can delegate this power to the police as well. If the detention order is for more than 3 months, under Article 22 subclause 4, such a detention requires the approval of an advisory board. So, if the detention order is for more than 3 months, advisory board, advisory board approval is required. So, this board are set up by the states and normally consist of retired judges and bureaucrats. A detainee is not generally allowed for the legal representation before the board. And if the board confirms the detention, the detainee can move court challenging the detention order. Now, under Article 22 subclause 5, Constitution mandates that the state is required as soon as may be to communicate to the detainee the grounds of detention, that why the person has been detained, and shall afford him the earliest opportunity of making a representation against an order. So these are all the technical requirements of why the particular detainee has been arrested. The grounds of arrest has to be communicated. The representation has to be done. It should not be more than 3 months. If it is more than 3 months, then advisory board approval is required. Now, basic set of facts that are grounds of detention are required to be communicated in one installment, and the state cannot then add fresh, new, or additional grounds to strengthen its original detention order. Okay? Now, the grounds have to be read in a language that the detainee understands. Now, the next clause, which is Article 22 subclause 6, which states that nothing in clause 5 shall require the state to disclose facts that the state considered to be against the public interest to disclose. So, if it is against the public interest to be disclosed, then the state is not, is not in a mandatory position to disclose the facts that why the particular person has been detained. How do court assess the detention order? Now let us talk about it. Now, how the court assess the detention order? For preventive detention, there are very narrow grounds of judicial review. Now, why it has narrow ground? Because the state has a subjective satisfaction when ordering a detention. So it is a subjective satisfaction of the state while the detention has been done. The touchstone on which the order is examined is this subjective opinion of the state rather than the fundamental right under the Constitution. When the court cannot substitute the subjective satisfaction of the state with its own satisfaction, it essentially means that it cannot check the veracity of the facts mentioned in the grounds of detention. Okay, a judicial review is very limited, whether the advisory board has applied its mind or not, considered all the material facts or not, whether the state showed obvious malafide in ordering detention. Because of the fact that judicial review is very limited, courts often strike down detention order on technical grounds, such as delay in decision of the advisory board, communication of grounds in a timely fashion, and in a language that the detainee understands. So generally, the judicial review of this particular law is very limited because it requires state subjective satisfaction, and that cannot be analyzed on the broader term. Okay. So, on this particular editorial, we tried to explain the preventive detention law, why it is under the review by the Honorable Supreme Court, and which state law is under the scanner. Now, let us move towards the national news of the day. $400 million Asian Development Bank loan has been approved to improve the urban services in India. So the Asian Development Bank has approved a $4 million policy-based loan to India for sub-program 2 of the Sustainable Urban Development and Service Delivery Program. Now, what is the program all about? A program aims to support the government urban reform agenda from improving the quality of urban life through the creation of high quality urban infrastructure, assured public services, and efficient governance system. The program also envisages integrated urban planning reform to control urban sprawls and foster systematic and planned urbanization through enhancing the entire ecosystem of legal, regulatory, and institutional reform, along with capacity building of urban services and community awareness. Now, this Asian Development Bank has been established in 1966 and it is owned by 68 members and 49 from the region. Okay, chale. The national news next coming up is Cyclone Hamoon weakens into deep depression. Northeastern states likely to receive light to moderate rainfall. So there is a severe cyclone storm Hamoon weaken into deep depression and likely to weaken further into depression in the next 6 hours. So this particular cyclone has been affected in the areas called Manipur, Mizoram, Tripura, South Assam, Meghalaya, Nagaland, Arunachal Pradesh. Cyclone storm hovered over Digha in West Bengal and Khepupara and Chittagong in Bangladesh. Meanwhile, severe cyclone storm Tej, which crossed the Yemen coast Tuesday morning, weakened into cyclone storm at 11:30 a.m. on Tuesday. Now, when we are talking about cyclone storm, let us discuss what is cyclone storm. Cyclone storm is characterized by a maximum sustained wind speed of 62 to 88 km per hour, while it is termed as a severe cyclone storm if the maximum sustained wind speed reaches 89 to 117 km per hour. The last such twin cyclones, which is Luban and Titli, were recorded in 2018. Now, Indians top the list of those seeking citizenship in wealthy OECD nations. India maintained its top position as the country of origin of new immigrants to the Organization for Economic Cooperation and Development Nations in 2021. It's a very big achievement. OECD is a group of 38 countries, most of which are high income and ranked very high on the Human Development Index. Out of those Indians who moved to OECD countries, 133,000 were granted nationality of this country, the highest among all countries. In taking nationality, India was followed by Mexico and Syria. So India tops the list of those seeking citizenship in wealthy OECD nations. चलें next news की तरफ चलते हैं. Vikram 1, an indigenous rocket with height of a 7-story building. Hyderabad-based space startup Skyroot Aerospace unveiled Vikram 1, a multi-stage launch vehicle with an expected space launch in early 2024. The rocket was revealed at MaxQ, the company's new headquarters in the city, inaugurated by Union Science and Technology Minister, Mr. Jitendra Singh. Now, what are the features of this particular rocket? This launch vehicle has a capacity to place 3,000 kg payloads in the low orbit. The rocket is an all-carbon voided vehicle capable of placing multiple satellites into orbit. Vikram 1 is among allied few rockets with the capability to deploy orbital satellites, says Skyroot. As tall as 7-story building, it is the startup's second rocket and comes after Vikram S, the country's first privately built rocket. The latter was successfully launched in November last year. And the Vikram is the launch vehicle. Name is a tribute to Vikram Sarabhai, the father of Indian space program. So Vikram 1, an indigenous rocket with a height of 7-story building. Okay. Now, Hyderabad to host second edition of E-Prix in 2024. So, the Federation International de Automobile and Formula E has officially confirmed the return of the Hyderabad E-Prix for the second edition, and it has been scheduled in the month of February 2024. Hyderabad secures a slot in the 10th season of Formula E, and have been included in Hyderabad in the final calendar for the 10th season of the Formula E Championship. This season will consist of 16 rounds, promising a thrilling competition for fans worldwide. Shall I? Asian Para Games 2023, Shailesh Kumar clinches gold in men's T63 high jump. India started the proceedings on the opening day of Asian Para Games 2023 in a bright note. Now, Shailesh Kumar clinched gold respectively in men's T63 high jump event. Okay. Now, prior to the Para Asian Games, Shailesh Kumar had an eventful outing at the World Para Athlete Championship, bagging silver. In the national championship held earlier in Pune, Shailesh went on to bag gold in high jump and silver in long jump. Now, let us talk about the background of this particular game. Asian Para Games is held in Hangzhou, the Public Republic of China from October 22nd to 28th. India sent 303 athletes, 191 men, 112 women to the 4th edition of Asian Para Games, making it country's largest contingent to the continental event. As at the Asian Para Games 2023, India have won 34 medals so far, with 9 gold, 12 silver, and 3 bronze. As of October 24th, available on Olympics website. So this data is based on the Olympic website, which is mentioned as on 24th October 2023. चले अगली नेशनल न्यूज की तरफ. Industry bodies to host global mega textile event Bharat Tex 2024, unveiling the future of textiles in India. Okay, so the world largest ever textile event in the world, he was presiding over the curtain raiser event for the show at Banjia Bhavan, New Delhi. Bharat Tex 2024 is scheduled to be held from 26 to 29 Feb. It is envisaged to be the biggest textile event at the global level, with exhibitors and buyers from over 40 countries. Bharat Tex 2024 would be a comprehensive showcase of the entire textile industry value chain, from India's rich cultural heritage and textile tradition to the latest technological innovation. So, Bharat Tex 2024. Indian Navy gets third guided missile destroyer Imphal. So, coinciding with the Navratri festives, the Mazagon Dock Shipbuilders Limited on Friday handed over Imphal, the third in the series of 15B class steel guided missile destroyer, to the Indian Navy. Imphal is the first naval warship with dedicated accommodation of women officers and sailors. Okay, now it is armed with the supersonic surface-to-surface BrahMos missile and Barak 8 medium-range surface-to-air missile. Towards undersea warfare capability, the destroyer is fitted with indigenously developed anti-submarine weapons and sensors, prominently the hull-mounted sonar Hamsa, NG, heavyweight torpedo tube launchers, and ASW rocket launchers. World Best Tourism Village, dedicated of people of Kutch, 6 p.m. as Dhordo wins UNWTO recognition. So, Prime Minister Narendra Modi, Union Home Minister Amit Shah, Chief Minister Bhupendra Patel, and State Tourism Minister Mullu Berka expressed delight recently with the Dhordo village in Kutch district being recognized as the world best tourism village by the United Nations World Tourism Organization. Dhordo is the only village that has been awarded with this distinction. Now, UNWTO is an agency of United Nations promoting tourism for sustainable tourism. Villages leading in conserving local values, sustainable development, cultural diversity, and local cuisine have been among the winners. A total of 9 yardsticks have been set for giving this award. इंटरनेशनल न्यूज की तरफ बढ़ते हैं. हेमन बेकले अमेरिका's top young scientist for developing skin cancer treating soaps. So Heman Bekele, a 14-year-old high school freshman from Woodston High School in Virginia, has garnered national recognition as America's top young scientist. So our indigenous soap has been developed by this, young man. Incorporates three key ingredients into medicinal soap. These ingredients have the unique ability to reactivate dendritic cells, which play a crucial role in generating an immune response to combat skin cancer. So, very appreciative of this young fellow. Football legend Sir Bobby Charlton passes away at 86. A renowned footballer, Sir Bobby Charlton, famed for his contributions to England's 1966 World Cup victory and his impactful career at Manchester United, has passed away at the age of 86. Charlton was diagnosed with dementia in 2020 and was celebrated as one of the football's greatest players with an impressive record of 249 goals in 758 games. Acknowledging his monumental influence, Manchester United praised Charlton as a globally revered icon known for his integrity, sportsmanship, and exceptional football skills, leaving an enduring legacy in the history of sports. South Korea, US, Japan hold first joint air drills. So the exercise, which involved a US nuclear weapons capable B-52 bomber, comes as Seoul, Washington, and Tokyo beef up their defense cooperation against growing missile and nuclear threats from North Korea. The trilateral exercise took place south of the Korean peninsula, where Seoul and Tokyo's air defense identification zones overlap, according to the South Korean Air Force. So South Korea, US, Japan hold first joint air drills. World first gender balance framework for the fourth industrial revolution debuted in Dubai. So it's a world's inaugural framework for the gender balance in the fourth industrial revolution, took center stage at Gender Balance and 4 IER workshop held as a part of World Economic Forum annual meeting of the Global Future Councils in Dubai. The framework is a result of collaborative partnership between UAE, Gender Balance Council, and the Center for the Fourth Industrial Revolution, UAE, an affiliate of the World Economic Forum. The Gender Balance and 4 Industrial Revolution workshop was inaugurated by Her Excellency Huda Al-Hashmi, member of UAE Gender Balance Council and Deputy Minister of Cabinet Affairs for Strategic Affairs. It was co-hosted by the UAE government and the World Economic Forum. The annual meeting of the Global Future Council attracted approximately 600 international experts and intellectuals across 30 councils, alongside governmental officials and representatives from international organizations and academia. Now, the legal update coming from the Honorable Supreme Court in the case of Ambala Parihar versus State of Rajasthan. Judges taking up cases not assigned by Chief Justice is an act of gross impropriety. So, Supreme Court recently held that judges should refrain from taking up cases not specifically assigned to them by Chief Justice of the court. If not, the roster notified by Chief Justice will have no meaning, the court said. The apex court said if it has not been assigned, it's an act of gross impropriety. The sharp remarks were made by the apex court with regard to the order passed by the High Court of Rajasthan in a civil writ petition praying for clubbing the certain FIR. The High Court had granted interim relief by directing that no coercive action shall be taken against the accused persons concerned. So the apex court said the judge ought not to have entertained such a civil petition for clubbing FIR when the jurisdiction of such matter is on the criminal side. So it talked about the administrative nature of how the Supreme Court and the High Court divide their cases according to the roster. Now, Supreme Court issues directions for sale and attachment of assets to clear arrears of maintenance to women abandoned by husband. So Supreme Court recently directed sale of the ancestral property of a man to pay arrears of maintenance of rupees 1.25 crore to his wife under the inherited powers under Article 142. So it's a very major judgment coming from the Honorable Supreme Court. The bench of Justice Ravindra Bhatt and Justice Arvind Kumar relied on the decisions of Apex Court in Subrata Roy Sahara versus Union of India 2014 and Delhi Development Authority versus Skipper Construction 1996 to observe that the Supreme Court is not powerless but can issue appropriate directions and even decrees for doing complete justice between parties. So there were arrears of maintenance and monthly maintenance on the ground that she was living with her widowed mother and was dependent on her for her expenses. So this was held in the case of Manmohan Gopal versus State of Chhattisgarh. Another legal update coming from the Honorable Supreme Court in the case of Assets Care and Construction Enterprises Limited versus State of Maharashtra. Once High Court admits a writ petition, it cannot refuse to consider prayer for interim relief, citing alternative remedy. So Supreme Court has said that at the order of Bombay High Court that first admitted a writ petition, but then refused to consider prayer for interim relief on the ground that alternate remedy was available to the party. The court has expressed surprise to an order of Bombay High Court on this particular, verdict. The apex court remitted the matter to the High Court, directing it to consider whether the interim relief needs to be granted or not. The bench, held by Justice B.R. Gawai and Justice Prashant Kumar, said that High Court has failed to exercise the jurisdiction vested in it by not considering the question of grant or refusal of interim relief after the matter had been admitted. The apex court was of view that non-granting of interim relief on the ground that there is an alternate remedy available is contradictory to the earlier part of High Court order admitting the matter. So once the writ petition has been admitted, then court cannot refuse to consider the prayer for interim relief, citing that alternate remedy is available. Now, legal update coming from the Kerala High Court in the case of Kuthira Lamputam Saji versus State of Kerala under Section 323 CRPC. Magistrate should record reasons for committing case to Sessions Court. The Kerala High Court had said that power under Section 323 CRPC to commit a case to the Session Court after the commencement of inquiry trial may be invoked by the magistrate only after recording its reasons by way of speaking order. The court found that as per Section 323 CRPC, a magistrate can commit a case when it appears to the magistrate that the case ought to be tried by Session Court. The court, on examining Section 323 CRPC, noted that magistrate has to record its reasons by way of speaking order before committing the case. That's all for the today's news update and the legal news. Thank you for watching. Take care.